Welcome to Denton's webinar on Bill 64, Modernizing Quebec Privacy Law, why it matters and how to prepare for it. My name is Chantal Bernier. I'm the National Practice Lead for Privacy and Cybersecurity at Denton's Canada. And I have with me my colleague, Alexandra Quigley, who is a litigator and who is also part of the Privacy and Cybersecurity practice. Before I start the presentation, I just have a few remarks to share with you. First of all, remind you that this is recorded and therefore you will have a copy of the record next week. Also mentioning to you, inviting you to write your questions in the Q&A button, and we will be happy to answer all of your questions after the webinar directly to you. And finally, for those of you who are members of the Bar of British Columbia or Ontario or Quebec, you can claim credits, 60 minutes of credits for this event. So let's move then to what we hope to achieve today, our agenda. Alexandra and I had to do some painful choices, I would say, because there is so much to talk about that, in fact, we couldn't cover everything. We've made the choice of honing on what we felt was of utmost practical importance now. But you may have noticed that in the title, we have a 1, because indeed there will be a part 2, which will focus on recourse. And I will talk a little bit more about that at the end of this webinar. But what we hope to do today, well, we hope to address why 64 actually matters beyond Quebec. Then what I really call the game changer, the fact that we've gone from a ombuds model where the regulator was merely making recommendations, the organizations would implement it, no financial consequences, unless, of course, we consider reputational damage or financial consequence, but there were no fines, no penalties. Well, that has all changed, and Alexandra will describe this new framework in a moment. There are new obligations for organizations, there are new rights for individuals, and a world premiere, there is now regulation of anonymized and depersonalized information. So we need to talk about that as well. Once Alexandra will have gone through all of these provisions, then I will come back and share with you how you can start implementing, making the transformation necessary to be compliant. So with that, I'd like to pass the floor to Alexandra.
Thank you, Chantal. Good afternoon, everyone. And so, as Chantal mentioned, I'm going to address one of the first great impacts of the new bill, which is, and the new law, which is the financial risks associated with the new measures and the powers that are granted, amongst others, to the CAI, or the Commission d'accès à l'information, which is the Quebec Privacy Commissioner. And so under the new act, the CAI can impose administrative monetary penalties, as you'll see on the next slides, or rather we can touch back on this. So as Chantal mentioned, Bill 64 and the new act will apply not only in Quebec, but can have some cross-border impacts, as the CAI, or the Commission d'accès à l'information, can exercise its competence even to impose sanctions or other restraints on organizations that are governed by PIPEDA. And the new law will create a unique precedent in Canada, which could possibly be reflected in other provinces. And as you'll see on the next slides, as I was mentioning, there is a financial risk associated with these new changes. The first being the administrative monetary penalties that the CAI can now impose directly on an organization. And these administrative monetary penalties can reach up to $10 million or 2% of the organization's worldwide turnover. The highest of the two is the maximum penalty that can be imposed directly by the CAI in cases of a variety of violations, including processing personal information violation of the new act, refusing to communicate information to the concerned person in violation of the various provisions of the act, failure to report a confidentiality incident or a breach. As we will see in a few minutes, there are new breach reporting obligations under the new act. And finally, failure to meet the obligations imposed on a personal information agent, which take on new meaning and further importance under the new act. And next, on the next slide, what you will see is there are also new penal offenses and fines that can be imposed on an organization under the new act. These can reach up to $25 million or 4% of the worldwide turnover. These violations that can lead to such penal offenses and fines also include processing personal information in violation of the act. So in such cases, the sanctions can be very onerous. There's also identifying or attempting to identify de-identified information without authorization. So the new act will be circumventing or limiting the use of that de-identified information. There's also sanctions that will be imposed if an organization impedes a CAI investigation, refuses to abide by an order rendered by the CAI, or refuses to produce documents requested by the Quebec Privacy Commissioner. And finally, matters of the financial risk. We have a new private right of action, which was the cause of much debate while Bill 64 was being reviewed and adopted, and it's in its final iteration, grants the court's power to award punitive damages of no less than $1,000 in cases where the infringement is intentional or is the result of gross negligence. And so this would allow a concerned person or an individual to claim punitive damages directly under the new act without having to go through the Quebec Charter. This was also an interesting development because it sets a minimum threshold for the punitive damages awarded if a right conferred by the act is violated, or if a right conferred by Articles 35 to 40 of the Quebec Civil Code, which pertain to privacy rights and to privacy rights are violated. Along with these sanctions under the new act come increased obligations. The first, which, as I mentioned, pertain to breach reporting, which follows privacy legislation elsewhere in the world and is new to Quebec. So first, under the new act, a breach incident or an incident is an unauthorized access, use, communication, loss, or any other breach in the protection of personal information. And these breaches must be reported to the Quebec Privacy Commissioner as well as to the concerned person if they present a risk of serious injury. And the risk of serious injury is assessed under the new act in light of the sensitivity of the information that is concerned by the breach, the anticipated consequences, and the likelihood that the information accessed by the breach will be used for harmful purposes. And so in a situation where there is a breach of the information held by your organization and there is a risk of serious injury, the breach must be reported to the CAI. The organizations also must now keep a register of the breach and any other subsequent breaches. And this register must be provided to the CAI upon request, which would potentially allow the CAI to identify organizations that have faced multiple breaches and therefore question what measures they are taking to protect personal information that they collect or use. There are also post-breach obligations or post-reporting obligations, which include decreasing the risk of serious injury and preventing subsequent breaches of the same nature. And so if the organization does not respect all of the breach reporting and the post-reporting obligations, it could be subject to the sanctions that we discussed a few minutes ago. Next, the new act requires and imposes a series of obligations that require a robust governance structure within an organization, as you'll see on the next slide. This first begins with ensuring compliance with the act. And so now every organization must have a person responsible for the protection of personal information, which we refer to as a data privacy officer. Now, under the act, it's presumed, or by default, the data privacy officer is the person within the organization that exercises the highest authority. These responsibilities can then be delegated to another person within the organization that will be responsible for ensuring compliance with the act. The name and the contact information of the organization's data privacy officer must be made public, notably on the organization's website. As you'll see on the next slide, the obligations pertaining to a governance structure also imply the publication and the preparation of policies and practices within the organization to best manage the personal information. Now, these policies and practices have to establish, firstly, the framework for the conservation and the destruction of personal information, the roles and responsibilities of the personnel members throughout the life cycle of the personal information. So from the moment of collection to destruction, as well as a process to review and assess complaints regarding personal information protection. And so these will be under the purview of the privacy officer that we just discussed. Now, as you'll see, there are also new obligations relating to transparency under the new act, and this lends into the robust governance structure that will need to be put in place within the organization, as these policies and practices must be available to the public and to the concerned persons via the company's website. They must also be approved by the privacy officer, and the policies and the practices have to be proportional to the nature and the importance of the data that is being processed by your organization. Next, the new act is centered on the concept and consent. And so this is a very important aspect of the new act. Consent must be clear, free, and informed. It must also be given for specific purposes. And moreover, the consent must be obtained for each purpose for which personal information is collected. Now, keep along with the transparency requirements and the accessibility requirements, a request for consent, must be separate from any other information that is provided to the concerned person. And so it must be clear to an individual that the organization is seeking their consent to collect or to use their personal information. The new act also introduces into Quebec privacy law the concept of implicit consent, depending on the type of personal information that is being collected. And so under the act, when personal information is sensitive, which means that due to its nature or to the context entails a high level of reasonable expectation of privacy, then the consent must be expressly given. If not, there are certain situations, if we're not dealing with sensitive personal information, there are certain situations where implicit consent will be sufficient. And finally, the consent of a minor under 14 years of age is given by its tutor or by the person with the authority. Now, there are also situations under the new act where personal information can be used without, once again, seeking the consent of the individual concerned. And so these situations include if the purpose is consistent with that of the initial collection, when it is necessary to prevent or to detect fraud, or when it is necessary for the organization to supply a product or to deliver a service to the concerned person. And on the next slide, as you'll see, as I mentioned, transparency is a key issue and a key element under the new act. And so this is first done by providing with the concerned person with a variety of essential information upon collection, which includes the purposes of the collection, the means used to collect the personal information, and informing the individual of their rights. Some of these rights are new under the act, and we'll go into further detail in a few moments, which include the right of access and to rectify the personal information that is collected, as well as the right to withdraw consent that was given upon collection. This transparency, as I mentioned, also has an impact on the information that is published and then must be made available to the public via the policies and the practices, as well as the contact information for the privacy officer. And finally, the new act goes so far as to mention that the privacy policy must be drafted in clear and simple terms in order to allow the individual to understand how their personal information will be processed, as well as to what they are consenting. Next, as Chantal mentioned, very interesting and new element of the new act has to do with depersonalization and anonymization, as you'll see on this slide. So under the new act, the de-identified information or de-identified data refers to information that can no longer be used to directly identify the concerned person. This can be reversed, and so de-identified information can be subsequently re-identified. Now, When it comes to anonymized information, the information no longer can be used to directly or indirectly identify the person, and this is irreversible. Now, under the new act, the right to use the information will vary depending on whether it is de-identified information or anonymized information. So, for example, the use of depersonalized information is subject to restrictions in order to prevent against unauthorized re-identification. And as we saw, if an organization proceeds to re-identify information without authorization, they could be subject to very severe sanctions. Whereas the use of anonymized information is subject to what the law refers to as generally accepted best practices. Moving on, there are also new rights for individuals that are granted and are provided for under the new act, the first of which is the data portability right. Now, this is very interesting because data portability has several aspects, which is first, an individual now has a right to request that the organization communicate the personal information that was collected about them. They also have the right to ask that this personal information be communicated from your organization directly to a third party or another organization in order, for example, to avoid being subject to another data collection. Now, this information has to be provided by the organization in a structured and commonly used technological format. This will require some preparation, as Chantal will discuss, on the part of the organization, and having a system in place with your privacy officer in order to be able to respond to data portability requests. There are certain exceptions in which an organization can deny a request. The first is in a situation where it would cause the organization serious difficulties. The other important distinction is that data portability right does not extend to information that is created by the organization or that is inferred by the organization from the concerned individual's personal information. And so what the individual is entitled to using its data portability right is the initial information that was collected. What is created down the line does not necessarily have to be provided to the person, upon request. The next right under the act is a right to be forgotten. And so the first iteration of that is for a person to have the right to request that the organization cease disseminating personal information that was collected. The next aspect is the right to request that the personal information be de-indexed. Now, there are conditions that have to be met in order for an organization to accept these requests. The first is that the dissemination of the information has to cause serious injury in relation to their right to the respect of their reputation or privacy. We also have to weigh this injury against the right of the public to have access to the information. And we have to make sure that the cessation or the dissemination does not exceed what is necessary for preventing the perpetration of the injury. Now, another aspect, another right that is awarded under the new act is the right to request that inaccurate, incomplete, or incorrect information be rectified. There is a general right that is given to an individual, and this right, as we will see shortly, also has an impact in terms of automated decisions. Which brings me to the next slide, which is automated processing. Under the new acts, an organization has to inform an individual when their personal information is used to render a decision based exclusively on an automated processing. Now, an automated processing means that there is no human intervention in the use or the analysis of personal information. So the organization's obligation is to inform the person that such a decision is being rendered upon request from that person. The organization must then provide information regarding the decision-making process, which includes what personal information was used, the reasons for and the parameters that led to the decision, and they must inform the person of their right to amend or to rectify the personal information that was used to correct the decision. And finally, the concerned person has a right to submit observations regarding the decision to the organization, which once again calls upon the privacy officer to receive and to manage the submissions provided by the person. Which brings us to our next section, which is the need for organizational changes within the organization, which will be discussed by Chantal. Thank you all very much.
Thank you, Alexandra. At the risk of stating the obvious, you all will know that clearly all of these changes will need some structural adaptation. There will have to be transformation to be compliant. So that's what I'd like to get into now, sort of step by step, what you should do to really make sure that you are compliant in a, let's say, the painless way, or anyway, minimizing the pain. But first, let me put it in context. I mean, this is a trend. The focus on accountability, as we've seen it as has just been described by Alexandra, for example, the emphasis on having someone responsible for privacy protection in the organization, that already existed, as you know, under PIPEDA, but now under 64, and beefed up, I would say. It is in a context of broader focus on accountability. So we'll start with 2018, the European General Data Protection Regulation, the GDPR, made mandatory the appointment of a data protection officer for certain companies. The obligation to keep a record of processing is also a requirement that corresponds to the desire to have not only accountability, but demonstration of accountability. Mandatory data protection impact analysis for certain initiatives is again another form of actually holding organizations responsible to document their protection of personal information. If we look at former Bill C-11, died on the order paper, but it did contain an incorporation of the model code for the protection of personal information in relation to accountability as in other principles. So it really became a formal legislative requirement. And Bill 64 makes that requirement specific as well. And if we put that in the larger context, for those of you who have read the white paper of the government on Ontario on the tabling, drafting first, but tabling perhaps a privacy law for the private sector in Ontario, I was struck anyway by the references, the number of references to Bill 64 with great positive endorsements. So I think we can see that moving in that direction in Ontario as well. So if we move to the next slide, let's start with, well, what does an organization do to be compliant now? So first of all, review the privacy program. Is the current privacy program you have compliant? Do you even have a privacy program? For example, lots of organizations have, for example, an excellent privacy policy on their website. They have excellent measures, security measures on their systems, but they don't have an actual program to coordinate compliance and ensure compliance throughout the organization. And that is now required. So Alexandra mentioned a moment ago, whatever you call it, data protection officer, chief privacy officer, or you can even find another name, but there will be someone who has to be responsible for compliance in the organization. And that person can be really what you feel is most appropriate in your organization. So for example, the law says by default, it is the person in highest authority. So we'll say the CEO. And there are organizations where that would make sense because they are very small. And indeed, the CEO pretty much does everything. And then it would make sense that the CEO is also the person responsible for compliance with personal information. But there are other organizations where it could be the general counsel because it's a legal compliance issue. Other organizations where the general counsel is separate from a compliance officer who is responsible for privacy compliance and perhaps other regulatory compliance. My point is that you really have to take into account what works in your organization to be effective. But there are some fundamental criteria that you have to keep in mind. You have to pick someone who has enough expertise to be able to guide the organization. That doesn't mean necessarily a lawyer, but someone who knows enough about the law to be able to direct the organization towards compliance. The other thing is it has to be a person who's at a level that has enough authority to, well, compel compliance is a strong word, but at very least elicit it, because you want to make sure that people listen to that person. You also have to make sure that the person is independent. This really struck me with one client who had assigned responsibility for protection of privacy within the organization to their CTO, their Chief Technology Officer. Well, that's a conflict of interest. The CTO is one of the many persons who has to implement policies and practices for protection of personal information. So you need a challenge function to make sure that this is done appropriately. So let's call it the Chief Privacy Officer and say the CTO or the CIO have to be very well connected, but make sure that you do preserve an independence around the function of assurance of compliance with privacy law, so that you can have a challenge, an internal challenge function. Another critical piece of a privacy program, of course, is a breach response plan. As someone who is breach counsel in so many cases, sadly, breaches are frequent. I can tell you the difference between an organization that had a breach response plan and the one that did not, in terms of results in the breach response, are very clear. So I'll give you two specific examples. One came to me. The facts are this: Sunday morning, an accountant in their financial services logged in because she needed to do some work. She noticed that something was amiss. And because the organization had a breach response plan that had been properly socialized through the organization, she knew exactly what to do. She recognized this, what this was, and she knew exactly who to call. And sure enough, within 30 minutes, they had stopped the attack. They still were a victim of ransomware, but they knew what they were dealing with. And therefore, it was fairly easy, if I can say. Anyway, we were efficient. They were efficient in intervening and reducing risk, which is critical. The organization is judged for that. The other example, another wonderful organization, but didn't have a breach response plan. So the breach probably occurred on one day. They found out over 2 weeks later. Then they came to me and forensic investigators another 2 weeks later. You could see that they were struggling with what to do with this. And of course, it didn't go well at all. The organization was profoundly ethical. It was wonderful working with them to see how much they wanted to do the right thing. But we were so hampered by the fact that not having a breach response plan, they had no assignment of who does what and what comes next. So that has to be absolutely done. And even if you have a breach response plan, well, you're going to have to look at whether it meets Bill 64's requirements. So, for example, as Alexandra said, the notification of individuals is conditional upon whether there is a risk of serious harm. Well, you're going to have some criteria, as well as a decision-making process within your organization to determine whether indeed, if you do suffer a breach, it is a breach that creates a risk of serious prejudice or not. So that's something that needs to be built into, even if you have an existing breach response plan. It also has to be communicated to employees. Has it been sufficiently communicated to employees? And of course, since you're going to have to update it, well, it will have to be communicated to employees again, because it will be a new breach response plan. If we go to the next slide, another critical building block, let's call it, to a privacy program and to personal information management is a data inventory. Going back to my second example, the organization who didn't have a breach response plan, well, they also did not have an inventory of their databases. So at the beginning of when they discovered the breach, they figured, well, maybe 200 people were impacted, and they didn't think there was any personal information involved. As the forensic investigators progressed, they saw that actually there were thousands of people involved. And not only was there personal information, but there was sensitive information in those databases, such as SIN, such as credit card numbers, a completely different picture from what the organization had assumed at the beginning, because it had no inventory of its databases and therefore could not identify the impact of a cyber attack encryption of this database versus another. So it really is critical to start with a data mapping of what type of information do you hold, why do you use it, really attach it to each purpose so that you can manage the purpose, the use, so that it is consistent, just as Alexandra said. You have to use personal information in a manner consistent with the purposes for which it was collected. Well, to manage that, you've got to actually identify the purpose for which you have this or that information. The other thing is that it is also a way to demonstrate accountability. So one thing I've seen is either staff or clients who will contest the collection of a certain piece of information. Well, if you have already good data mapping of, we collect this information for this reason, you just show that and show that indeed you have done due diligence and you are not holding personal information beyond what is needed to provide the service or the product. One example is the data retention requirements under the Income Tax Act. So I have often seen, for example, customers challenging the fact that an organization still had their personal information, but the reason was that it was required under the Income Tax Act. So the information was there, so you really have to document this. Also, you need to know whether you have sensitive information, because by law, sensitive information must be protected at a higher level. So these pieces of sensitive information may have to be held separately or may be subject to more restricted access rights, even if they are in the same database. There may be a segregation that has to be implemented between some information and the other personal information because one is so sensitive. So really, really important to do an inventory of your databases. Then you have all of the practices and procedures that you need to actually implement your protection of personal information. So for example, collection of personal information. Does your staff know what the rule is around limitation of collection? Unlike a retail store where I went, as I go to the cashier says to me, first, I need your email. Well, no, not first, you need your email. You know, it's, would you like to give me your email so that I can send you promotional emails? But clearly that staff person had not been educated at all about the obligations of limitation of collection. Limitation of use, very important. Once the information is inside your organization, very important that everyone knows what it is for, and so that the purpose remains consistent and you can manage that and measure that. Then Are you sure that you have the right level and nature of consent? So as Alexandra said a moment ago, there are some collection of personal information that are subject to express consent. Other can be done with implied consent. But you're going to have to look at your consent mechanisms to make sure that you indeed have the right form of consent for each type of collection. You're also going to have to make sure that you do have the specificity that is now required. Each purpose must be consented to specifically. So you're going to have to find a way that does not cause too much friction and yet meets the legal requirements on consent. Then, do you have retention schedules? There are so many organizations that do not, and that obviously is not only an issue because it is required by law, but also because it is forbidden to keep personal information beyond what is necessary. So if one doesn't have that, well, then it is impossible to know when to destroy the information. And on top of that, keeping information indefinitely is creating a tremendous vulnerability, of course, to breaches. So that's definitely a must. And protection of personal information. Do you have the right practices and procedures? For example, and not just technological, but physical. Have you considered what remote work is causing in terms of a privacy risk in your organization? Or when you come back, open areas, have you addressed the risk? So those are all of the questions that we just need to take a step back and say, do we have all of the internal mechanisms to make sure we comply and we measure our compliance? And call me biased, and I will accept it, but I'm referring to you to at the bottom of the page, a document that in fact I released when I was at the Office of the Privacy Commissioner of Canada with my then counterpart of the British Columbia Information and Privacy Commissioner and the Alberta Information and Privacy Commissioner. And it's a guide called Getting Accountability Right with a Privacy Management Program. What we intended to do there is simplify things for organizations, give them a step-by-step to build a privacy program that is not overly complicated and meets the legal requirements. And you will find it on the website of the Office of the Privacy Commissioner of Canada. Of course, it has to be updated because there are new requirements now, is what I'm going to address. So yeah, new requirements, including the requirement to develop privacy impact assessments for certain activities. So where you establish or even update an information system, electronic system delivery, or any processing of personal information through an electronic system before transferring personal information outside of Quebec, or before disclosing personal information without consent, de-identified, but without consent for the purposes of research or study, then you need to do a privacy impact assessment. It may seem like a burden, but actually I am quite partial to PIAs because having had to do them when I was leading organizations, having reviewed them when I was at the Office of the Privacy Commissioner of Canada, doing them now for companies, I see the value of a PIA as a tremendous risk management tool, because that's precisely the point. You assess what is your privacy exposure. What are the privacy risks that project or a product entail? Having identified the privacy risks, then you can identify what the mitigation strategies are. And then you have an action plan to implement them so that you can check, do we have everything we need? And you have a benchmark to verify compliance on a regular basis. depending on the sensitivity of the issue, you may have a more frequent review of your PIA and compliance with it, or a little more stretched out. But you really, I think you will find it extremely helpful. So what you need to do is, first of all, identify for your organization, when is it that it's going to be necessary according to your operations? When are they going to call for the development of a PIA? Then you're going to have to assign responsibility. Who is going to do the PIA? Who's going to be responsible for doing PIAs? Will it be the owners of the initiative, or will it be a centralized privacy officer function? It depends on what works for you best. You also have to have a procedure in place for consulting the head of privacy compliance, so that that person can make recommendations, verify, etc. And then you may want a template, an analytical model that will be the same for every PIA in your organization, so that you have consistency in that regard. And you're going to have to also have a development process that will make sure that you are really well aligned with the approval of the PIA. Once the staff have assessed, well, this is a privacy exposure, this is the mitigation strategies, it has to be endorsed and approved to be the way forward as having properly managed the privacy risk for the organization. Again, I do give you a reference from the public sector, but the fact is that the public sector has been doing privacy impact assessments mandatory for decades. So if you look at the Treasury Board Secretary of Canada's directive on privacy impact assessments, you may find a basis to adapt to your own organization. So if we move to the next slide, the PIA to transfer personal information outside Quebec. So why do I want to focus on that specifically? The thing is that there's a broader context here. Data residency requirements are increasing. And in fact, it has been for a while that even in Canada, the Office of the Superintendent of Financial Institutions, as well as the Office of the Privacy Commissioner of Canada, have said that they expected organizations to take into consideration, before they outsource transferring personal information abroad, the local conditions of protection of personal information, including the local law, including the political system and its stability. Is it a democratic system? Is it a country where the state respects the privacy and therefore does not seek access to personal information held by, for example, your service provider? So there's a bigger context. This is not entirely new. And for those of you who have European data, well, of course, you know about the Schrems II decision, which imposes upon personal organizations to check whether the countries to which they send personal information, when it's sensitive, that indeed the country has the system, the legal regime to protect it appropriately. Well, Bill 64 makes that a requirement, needed to do a PIA to make sure that the destination, we'll call it that way, offers adequate protection. So how do you implement that? Well, first of all, you have to decide what kind of risk are you ready to take. So for example, one organization has asked us to do a risk assessment of their entire supply chain. Their suppliers store personal information altogether in 25 countries. So what we did is we asked 25 of our Denton's colleagues in 25 countries to tell us replies to a questionnaire so that we would assess the level of protection of personal information in that country. On that basis, we identified what countries were really very low risk. You can outsource, no worries. Those where we would think, ooh, maybe it's better to actually add some contractual clauses to beef up the protection. And then other countries where really the organization may want to think like, really, we really want to use a service provider who stores personal information in that country? Do we really want to take that risk? And so doing that PIA is actually in line with the reality of risk of transferring personal data abroad and the expectation of regulators, not necessarily new, to make sure that the transfer does not compromise the security of the personal information by going abroad. So if we continue, the next slide is de-identification and anonymization, where, as I said, this is the world premiere. It never has been in Canadian law that we would have regulation of de-identification and anonymization. The most we have is a reference in clause 4.5.3 of Schedule 1 of PIPEDA, where it is stated that at the end of its necessity, personal information must be destroyed or made anonymous. So anonymization was equated to destruction. But that's it. We took the view, as it makes sense, it's logical, that once the information is anonymized, therefore it does not relate to an individual, but it's no longer personal information, and therefore personal information protection law no longer applies. That is in fact the case for the General Data Protection Regulation. But that is not the case now in Canada, specifically in Bill 64. So first of all, for the first time, we have a legal definition of de-identification. So de-identification, for those of you who are familiar with GDPR, is akin to pseudonymization. Essentially, you're replaced de-identifiers with a hash or with a code, and it can be re-identified, as Alexandra was saying a moment ago, through, for example, a matrix of identification of substantive information to the actual name via the code. So that remains personal information and use is limited. Anonymization, as Alexandra said, it's irreversible separation of identifiers. I mean, there's really no way you can reconnect. And yet, this is the big change. There is still regulation now. It is still subject to demonstration that use is for a serious and legitimate reason. So what are you going to do? I mean, a lot of you, I am sure, anonymize data to analyze trends, to have all forms of knowledge that is relevant to your business. So, well, obviously, it'll be important to make sure you have reliable technologies, because the Act now includes that requirement that it has to be technologically sound. The anonymization has to be technologically sound. It will have to be important to supervise internal use, because now use has to be serious and legitimate, but also it'll have to be defined. For each organization, it may be a different type of use that is serious and legitimate. So you're going to have to develop those parameters for your organization. And you're also going to have public documents where you explain the process, because that is now a transparency requirement. If we move to the next slide, the mechanisms for responding to individual rights. So again, I go back to what Alexandra mentioned. There are brand new rights created in Bill 64. So let's start with the right to access, the reasons for which an automatic decision was made about an individual. The individual now has the right to access the personal information that was used to make the automated decision. Well, you need a process to be able to respond to that request because it is now a right in law. On top of that, the individual will have the right to present observations. Well, you need a process to receive those. So clearly, the right of access to the process of automatic decision-making will have to be addressed in some form of mechanism inside the organization. Then the right to be forgotten, where it's even more vague and your staff will really need guidelines, because the right to be forgotten is the right to have de-indexation or cessation of dissemination where there is considerable prejudice, and this prejudice is not greater than the public interest to make the information known. That is very difficult, I think, to assess. It will be very important to have proper guidelines to inform your staff as to when the right to be forgotten will be granted or not, but also the right processes. Like, at what level will it be appropriate to ask a person to make that kind of determination? So that's another transformation that has to occur. Then the right to portability. So the right to portability, Alexandra mentioned it, will require, of course, technological changes to make sure that you have interoperable infrastructures to make that portable information actually transferred. But there's also this determination. The right to portability does not apply to information that is created or derived from the information that was provided by the individual. Well, again, there is a determination there, and it will be important to have guidelines for your staff so that the information that you have created or derived from the personal information of the customer, which is really subject to your intellectual property rights, is not transferred via the right to portability. So again, a process as well as guidelines and criteria to make sure that you are compliant. So if we go then to the last slide, this is where I'd like to share with you 5 lessons that I've learned reviewing internal compliance programs. So one service that Dentons offers is to provide organizations the review of their internal compliance mechanisms, not to tell them whether they're compliant or not, but whether they have effective compliance mechanisms, whether their compliance mechanisms are sound. And doing that, I really have been struck by some key factors of success. The first one, there's no point in running, you have to start on time, or early warning systems. Well, obviously, you need to start as soon as you find out what is the new test you have to meet. And that is now, even though the law does provide for transition periods, they'll go very quickly. So that's the first thing I found, that organizations that had given themselves a good leeway to transform did it in a much easier way than those who were crushed and then, actually had a lot of internal tensions about it. The second thing is the critical decision of who the chief privacy officer, data privacy officer, call it what you will, is. That person will need to rally the troops. So that person has to be not only in a position to be able to do that, but also capable of doing that. Then you need to make sure that you plan. This is an exercise that needs to be planned. So you need to do a gap analysis and see among the gaps, which are the ones that are highest risk for you? Where a gap in compliance for you is a high risk, well, obviously that'll be your priority number one to address. But when it is a low risk, well, then you can obviously delay. Then you need to allocate the resources that will be necessary to actually make the transformation happen. And compliance must be supported by a culture of protection of personal information. And in fact, just this morning, Alexandra and I were talking to an organization who was describing to us how they have instilled a culture of protection of personal information that really helped them give roots, entrench their compliance measures in the organization. So all of that, I hope, is of assistance. And we wish to thank you for being with us today. But I also want to tell you that we do have a follow-up. As I said right at the beginning, we couldn't put everything in. So we have on November 4th, another webinar specifically on de-identification and anonymization with Dr. Caleb El-Imam, because he is a specialist in de-identification and anonymization, and he will tell us what it is you need to do, what is the level of anonymization or de-identification you can expect, which is now a legal requirement, as well as a webinar in both English and French on the remedies of organizations, how you can protect yourselves, how you can defend yourself, because the Act actually does provide for some consideration in the definition of fines, for example, as well as some recourses against a decision, for example, of the CAI. So this is to come because there is so much to cover. So in closing, I want to remind you that you will receive this recording by mail and that we look forward to receiving your questions and we will reply to them. With that, I wish you a very good day. Thank you so much.